Okay, so I'll start anyway. Just to give you an overview of my presentation, I will give you a brief introduction in terms of why this topic today, share with you very briefly the research that has been conducted in the Caribbean that I author with Justice Rosa Peroni of the Inter-American Court of Human Rights about human rights to respect sexual orientation and gender identity in the Caribbean and Latin America, current situation and perspectives, which was published in March 2021, and which actually focused on, in the Caribbean, in the study of certain cases that have led us to the conclusion that the Privy Council is hindering progress of LGBTI rights in the Caribbean region. And then focus on the topic of today from there, to explain why the Privy Council got it totally wrong in construing the saving clause for Trinidad and Tobago, both as a matter of principle, but also as a matter of law. And finally, have a few concluding remarks. I was hoping to be able to show a PowerPoint presentation, I think we are almost there, in which you will be able to see the American continent and the enforcement of human rights, particularly on how they overlap with LGBT rights. For those who don't have that, but have the paper print version, if you move to the third actually slide, you will notice that there is the American continent from Alaska to Tierra del Fuego, mainly in light blue. That trying to show that all that part of America is actually either providing with equality for LGBT people in the continent, or on track to deliver equality for all LGBT people in the continent. If you look carefully, you will see that there are 35 countries in the American continent. 22 are bound by the Inter-American Convention on Human Rights. In 2018, the Inter-American Court says that the convention requires same-sex marriage. The two main economic powers in the continent, Canada and the United States, they haven't ratified the convention, they haven't accepted the jurisdiction of the court, but Canada opened same-sex marriage in 2005 by law of parliament, and the United States did that in 2015 by decision of its Supreme Court. Finally, in the English-speaking Caribbean, we have 12 nations and 5 overseas territories, which are dependent from the United Kingdom. And you will see that those 5 territories and those 12 nations, both 8 of those 12 nations, are signaled in the map in yellow and red. Those jurisdictions are the only jurisdictions that are under the umbrella of the Privy Council, still as the final court of appeal. There are 4 countries, English-speaking countries, that have ditched the Privy Council and have accepted the jurisdiction of the Caribbean Court of Justice. Those 4 countries are Barbados, Guyana, Belize, and Dominica. Those countries are in blue in this map because they're on track towards equality. In 2018, the Caribbean Court of Justice issued a judgment in which it declared unconstitutional the laws in Guyana that criminalize transgender people. So that is the right step in the right direction. But what is going on with the Privy Council? If we move to the next page, you will see that the research in the Caribbean has actually shown that the Privy Council is hindering the progress of LGBT rights in the region because it maintains the validity of colonial laws over the constitution of independent nations in perpetuity, and I reference the cases there, but also it promotes discriminations on grounds of sexual orientation, and I refer the case there. This is interesting, this conclusion that we reached and we published in March 2021, particularly the first one, that the Privy Council maintains the validity of colonial laws that actually are affecting the progress of LGBT rights, have been very recently, in July 2021, confirmed by the Attorney General of Trinidad and Tobago. And I'll see if I can share with you just 1 minute of an interview that he gave in July, because this is very telling. This is the Attorney General of Trinidad and Tobago. If it's just too complicated, we'll move it. If we could put 1610. I don't know that. 1610. Okay, that's fine. Well, we cannot do it. That's fine. We could. So going to
civil proceedings
that's fine.
the electronic digitization of courts and structures.
Appeal the landmark decision. What's the decision from the Privy Council?
Great. Reason. Let's say why we're appealing, because we could have stopped there. So in the Jason Jones matter, there was a challenge to the sodomy law. And that is one of the laws that treats with discrimination. And there are actually 27 other laws just like that. People may not know it. The Cinemas Act, the Hotel Act, all of these things don't allow for certain circumstances. It was necessary in the Jason Jones matter for two reasons to appeal the decision. Number one, it is important for us to get to the highest court of the land, that's the Privy Council, so that the Privy Council can say whether they agree that the law ought to be saved or not saved. Because once they make a decision on that, we know what to do with the other 27 laws. So certainty of the law is one process. And in this country, we're not a theocracy, we're a democracy. There are very heartfelt views, both for and against the issue. So to avoid having to be Solomonic and cutting the child in two, it is responsible for an Attorney General to recommend an appeal in the matter so that we can settle the law. Once the law is settled, we know where we go from there.
I'm glad you said a bit not.
So can we move to the presentation again? So the research found this, shockingly, these cases. We're going to focus today on the saving clauses. And basically, for the public to understand, the saving clause is a reference to a constitutional clause that was inserted in the first 5 constitutions at the time of independence in 1960. These clauses basically prohibit the court to rely on the Bill of Rights of the Constitution to invalidate a colonial law. That is, a law that has been passed before independence during the time of the British Empire. Now, the way in which the court interpreted this clause in the cases of Boyce and Math in 2004 was to provide an absolute immunity to colonial laws against nullification or modification via the judiciary. Only Parliament, Lord Hoffman said, can modify these laws. The court cannot touch them. In practical effects, this is the best situation in which a dictator could be. No accountability. Provided that that person, that government, is enforcing a colonial legislation, there is no accountability possible in the jurisdiction by the local judiciary. So, but more shockingly, Lord Hoffman said in his judgment that it doesn't really matter how degrading or inhumane these colonial laws are. Their immunity is absolute. Now, I would like the audience to think about this, because can we imagine if the Russian Supreme Court today were actually to write something around those lines? Or the Chinese Supreme Court were to write something around those lines and make a public judgment about that? It doesn't matter how inhumane and degraded the laws passed by the Russian parliament or the Chinese parliament are. The judges cannot touch it. They only can enforce them. I mean, it's shocking that this judgment was written in 2003 as well. We're not talking about 19th century. We're not talking about early 20th century. We're talking 2003, 2004. I think it's interesting also for those who are not familiar to read the dissenting judgments. The dissenting judgments, the judges are horrified the way the majority was going into it. And so I would like to explain why this decision was wrong as a matter of principle. And let's move to the following slides for those who do not have a PowerPoint in front of you. Because one of the fundamental errors is a matter of principle. I think common sense clearly, but as a matter of principle. And this was clearly explained to us by Lord Bingham a few years later in the case Bow versus Regina, which was a case from Bahamas, also dealing with the saving clause of the Constitution of Bahamas, in which the Privy Council in that case, as a matter of construction, went in the opposite direction. Lord Bingham said, we have a problem here. We do not understand what a constitutional adjudication is. We have failed here. He said constitutional adjudication of primary legislation is something we are unfamiliar with. And that is correct, because the British judges do not have a tradition or the legal ability to declare void and inoperative an act of the United Kingdom Parliament. If we think how our system in this country is organized, we have parliamentary supremacy, sovereignty of parliament as the basic principle that actually binds us together and from which the legality of everything evolves. Even common law, when a common law decision a case law is being made and Parliament disagrees, Parliament has the legal power to override that. So always Parliament is at the top of the pyramid. In the times of the Empire, when we were creating colonial territories, of course we cannot have two sovereign parliaments. Sovereign, there's only one. So the way in which the British Empire organized itself was by creating letter patterns which will provide the framework under which the colonial territory will be organized. And so the paradigm for the territories was changed. It was changed to a paradigm in where, rather than Parliament being in the top of that pyramid, it is the Constitution that is in the top of that pyramid, and hence constitutional supremacy. The legality of everything that happens in the colonial territories evolved from that Constitution, whether it's legislation, whether it's secondary legislation, whether it's the decision of a judge. Everything comes from the top of the pyramid rather than from Parliament, from the Constitution. And so the Privy Council, which actually, before the cases of Boyce and Matthew, or a year before that, have looked into the saving clause, have actually made a decision that was, as a matter of principle, correct. Because in that case, the Privy Council says the colonial laws cannot be modified. That's what the Constitution says. That's what the saving clause actually states. But that doesn't mean that those colonial laws that are in breach of the Constitution cannot be modified by the judiciary if they do not comply with the Bill of Rights. And so in Rodin, 2003, the Privy Council actually made a decision in law and in principle that comply with that constitutional model. The Constitution remaining on the top. The following year, when Matthew and Boyce were actually handed down by the Privy Council, he reversed Rodin. He reversed Rodin and make the decision that the judiciary cannot touch the colonial laws, regardless of them being inhumane or degrading, and that immunity is complete. In this decision, the Privy Council reversed completely that constitutional model of hundreds of years of existence that was inherited by those independent countries. It put the colonial laws beyond and above the Constitution. Imagine the paradox of this. Laws passed by the new parliament of the new independent nation can be declared void and inoperative by the local judiciary. But the laws passed by Queen Victoria 200 years ago, or passed by 500 years ago by Henry VIII, cannot be touched by the judiciary of those independent nations. This is completely unprincipled and unreasonable decision. This is exactly what the Caribbean Court of Justice said in Gervais and McEwan in 2018 when it addressed for Barbados and Guyana the decision of the Privy Council in Matthew and Boyce, and says Matthew and Boyce are incongruous decisions. This is actually rightly so, and in return simply to roll out. It says the judges have the duty to modify colonial laws which are not in compliance with the Constitution to secure constitutional supremacy, returning to the empire model of the constitutional supremacy at the top of the pyramid and restating a principal decision. Now, you can tell me, Leo, listen, the Privy Council are judges, they have nothing to do with justice, they have nothing to do with principle, they have to apply the law. If the law actually states that that is a decision, then tough. I mean, it just reminds me of Justice Holmes of the United States Supreme Court, early 20th century judge. He used laughing or joking with his friends when he would actually withdraw from a meeting. His friend would say, Justice Holmes, do justice. And the guy would turn his head and said, my friends, my work has nothing to do with justice, my work has to do with law. So we could actually be in a situation where the law will actually force the Privy Council to do so. But unfortunately not. As a matter of legal construction, the Privy Council decided that Rodal, the case they actually reversed, was perverse and irrational. And he said it was perverse because they believed that Rodal, by allowing the Crown, by an order in council from 1962 that included the power of modification of the judiciary, to modify the constitution of Barbados or Trinidad and Tobago, which was the mandate of the people of the nation decades later, was a perverse use of legislation. I'm afraid that the Privy Council here is missing the point altogether, because the independence of these nations in the Caribbean, in all circumstances, was actually the consequence of the Independence Act by this Parliament. In the Independence Act, Parliament gave unfettered powers to the Crown to promulgate the constitutions for these nations. Now, the Parliament could have qualified those powers. It could have said the Crown must listen to the people of Barbados and Trinidad and Tobago. The Crown might seek advice from the people of Trinidad and Tobago. The Parliament didn't do that. Parliament gave unfettered and qualified powers to the Crown to pass those constitutions. So, as a matter of law, whatever was the wishes of the people of Barbados in 1962 has no legal status. In this, by suggesting the Privy Council that they had to have some legal importance what the wishes of the people of Barbados was back in 1962, is actually creating almost a quasi-revolution, because it's confusing the situation of the Philadelphia Conference in the United States. If you remember, after the revolution in 1776, there was a constitutional conference that lasted for 10 years. And that was the wishes of the colony, to have the constitution they adopted in 1781. But in the case of Barbados, the independence was not by revolution. It was by concession of the British Parliament, of the Imperial Parliament, sorry. And so, in order to continue with the legality, what matters is what actually the order in council states. And that is an important mistake in law. Also, there are terrible issues with statutory interpretation, which I'm not going to go because I don't have the time to do so now. But there are terrible mistakes in law. The other point that I will leave because I don't have the time is the accusation that Rodel was irrational because immunized from constitutional challenge only laws which cannot be modified. This is wrong. Again, it misunderstands the powers of modifications. It doesn't match with the decision the same year the Privy Council took in Gaidam versus Godin Mendoza. And it is difficult to understand as a matter of law how they could have concluded that the matter was perverse and irrational. Just to conclude, here, is the Privy Council causing harm and hindrance? Well, indirectly, it's protecting criminalization and discrimination in perpetuity of LGBTI people in Trinidad and Tobago. Directly, it's providing for discrimination. Is it going to provide for segregation in the case of Bermuda and the Cayman Islands? They are sitting for 10 months in a judgment where the government of the Cayman Islands is asking for being allowed to give legal segregation of LGBT people on grounds of sexual orientation. We don't know what they're going to say. Thank you very much.
Thank you. Yes. Leo, thank you very much indeed. And moving on